The cold brass paperweight struck Section 4B hard enough to make both wine glasses tremble. The fire snapped behind me. Dry Malbec shivered against the crystal, then settled. Across the mahogany coffee table, Renata Lewis kept a brave smile in place while her hands remained locked together in her lap. Her right thumbnail pressed into the side of her index finger. The 80-page contract under the paperweight said Dorian Anderson could freeze her backlist royalties on Tuesday, claim the film rights to her best-known series, and extend a non-compete across her next 3 books. "You can stop pretending you are not afraid," I said. The words sounded rougher than I intended. Renata glanced toward the flames instead of the contract. She wore a beige cardigan buttoned over a modest cream top, and the cold rain had darkened the shoulders of the coat draped across my chair. "I am calculating," she said. "If the royalty account freezes, I have enough cash for 6 weeks. After that, the independent edition stops, the audiobook deposit fails, and my apartment becomes a question." Dorian's notice had arrived that afternoon. He wanted her film rights before announcing the sale of Anderson Press to a media group. He also wanted 20% of her next 3 independent books. The non-compete was his pressure point. The royalty freeze was the clock. Walking away meant losing the income from 10 years of work. Litigation could last long enough to bankrupt her, even if she eventually won. I lifted the brass paperweight. The metal had absorbed the winter chill from the front room and held it against my palm. It had belonged to my wife. For 3 years, it had remained on the same corner of the table, pinning down whatever document gave me an excuse not to think about the hospital. Tonight, it held Renata's career in place. "Why me?" I asked. "You audited 3 Anderson contracts when you represented the Calder estate," she said. "Your agency still has the historical rights schedules. No one else can compare his old boilerplate to what he is claiming now without starting from zero." That was the practical reason I had negotiated and audited comparable contracts. I controlled the agency records that could test whether Dorian's claim matched his actual chain of rights. Before attraction, before grief, before the fact that she looked at me as though I might still be useful outside a spreadsheet, there was work only I could do efficiently. I pulled the contract closer and put on my reading glasses. Section 4B ties the non-compete to formal acceptance of your 3rd manuscript. I said, "Do you have the acceptance letter?" An email. Received. Looks good. Nothing by certified mail. The missing acceptance strengthens an argument. It does not settle one. Performance and waiver still matter. She nodded once. No false reassurance. No magic clause. I uncapped my silver fountain pen and drew a narrow bracket beside the paragraph. Before I turned the page, I noticed the payer name on the attached royalty statement. Anderson Holdings, LLC. The contract named Anderson Press. Has the payor always been Holdings? No, it changed 2 years ago. Clue 1. I wrote the entity names in the margin. Renata leaned forward, then stopped herself before crossing the space between us. What happens next? We create a professional record before either of us touches your files. I called Vivian Shaw, an independent copyright attorney who had handled 2 rights reversions for my agency. She answered from a taxi, listened for 6 minutes, and told us not to open Renata's flash drives. "I'll send a limited engagement and preservation protocol tonight," Vivian said. "Pierce handles publishing history, royalty schedules, industry records, and the rights matrix. I handle legal advice, injunction response, sanctions, and settlement." Renata asked, "Can I terminate either engagement separately?" "Yes." "Fee cap?" "In writing." "Data access?" "Read-only exports, logged and hashed. Personal messages stay restricted unless you approve specific review." I looked at Renata. "You choose each next step." I said, "I'll build the publishing record. Vivian controls the legal response." The tension in her fingers eased enough for the thumbnail to leave her skin. Daniel Cho, my agency partner, joined the call next. He ran the conflict check, approved a capped agency fee, and assigned an internal matter number. The agreement stated that Renata could transfer representation at any time and that no personal relationship could affect her rights, income, or access to counsel. By 11, the documents were signed. Only then did I place the first flash drive inside a numbered evidence sleeve. The fire had burned low. The 2 glasses of Malbec remained untouched. Renata looked at them. "Do you always pour wine before reading a hostile contract?" I expected a shorter document. Dorian believes page count is a personality. That may be his strongest legal theory. Her laugh was brief, but it changed the room. Week 1 became an acceptance and severability review. Renata arrived at 6 each evening. After writing, the porch light was already on. Green tea waited in the chair beside the library window because she had mentioned once, years earlier, that coffee after 5 made her revise the same paragraph until dawn. I did not explain the tea. She did not thank me aloud. The work was explanation enough. My reading glasses, silver pen, and 2 versions of the contract formed the first competence set. Tool. Deliverable. Arena. I compared the original Anderson boilerplate, Renata's signed agreement, and the agency archive from the Calder estate. The result was a 12-page acceptance and severability matrix built in my home library. The missing certified acceptance did not erase 3 years of performance. It did, however, create ambiguity about when exclusivity began and whether the later non-compete amendment had ever attached. Vivian reviewed the matrix on Friday. This is useful because it shows the argument without pretending it is already a ruling. She said, "Pierce, keep the legal conclusions out of the publishing chronology." I have. You highlighted waiver in blue. It is a question heading. It looks argumentative. Renata tapped the page twice with my pen. Should I warn the paper? Vivian looked through the screen. I'm afraid to ask. Pierce aligns stationary when he disagrees. I moved the pen until it sat parallel with the matrix. Daniel, seated beside Vivian at the agency conference table, noticed. "Confirmed," he said. He has done that since junior agent training. The second light moment arrived through professional humiliation. By the end of the first week, Vivian sent Dorian's counsel a dispute notice and preservation demand. The notice did not stop the royalty freeze, but it required Anderson Press to preserve acceptance records, assignment schedules, and payment histories. The first loop closed. The payor name discrepancy remained open. Week 2 focused on delivery history. Mara Bell, a publishing rights auditor with digital forensic certification, came to my agency office to preserve Renata's email archive. Renata watched the export from beginning to end. Mara created a read-only copy, calculated a SHA 256 hash, and logged every folder. Personal correspondence moved into a restricted container. Before opening a thread labeled Sarah Private, I asked Renata. "That one is not relevant," she said. Mara marked it excluded. We did not read it. The certified mail records showed Dorian's office had acknowledged physical delivery of the third manuscript, but never sent the formal acceptance required by its own contract. Email headers confirmed the received "looks good" message came from a junior editor, not the authorized publishing officer. Again, not victory, but the chain weakened. Mara examined the preservation log. Clean collection. She said, no source changes, no private folders opened outside scope. Third-party recognition arrived through process rather than praise. The manuscript history produced another clue. The rights management database listed Anderson Press as the contracting publisher, but the royalty system switched to Anderson Holdings 2 years later without an author-signed assignment notice. Clue 1 deepened. Daniel looked at the entity line. If Dorian is selling the imprint, he may be trying to consolidate rights before due diligence. That is motive. I said, not proof of ownership. Good, he replied. Keep making that distinction. He waited until Renata and Mara left the conference room. Then he closed the door. You are sleeping? Yes. How much? Enough. You said that before your wife's memorial. and then sent contracts at 4 in the morning. The brass paperweight sat in my briefcase beneath the conference table. I had brought it from the library without deciding why. This case is under control, I said. Representation is not rescue. Pierce, I know. Knowing is not the same as behaving. He opened the door and ended the conversation before I could align the folders. Week 3 brought the foreign rights discrepancy. Renata's German publisher had paid a translation advance 18 months earlier. Anderson's summary statements showed no corresponding royalty credit. The payment appeared instead under a marketing expense line routed through Anderson Holdings. Clue 2. At the agency conference room, I connected the rights management database to the foreign license records and royalty schedules. Mara provided the certified payment export. Renata brought her German correspondence and organized the exhibit tabs by book, territory, and date. The deliverable became a backlist and royalty discrepancy report. Tool. Deliverable. Arena. Rights database, statements, and foreign license records. A documented royalty report. My literary agency, where those records belonged. The work should have ended at midnight. It continued until 3. The silver fountain pen dried out while I was marking entity changes. Renata removed the empty cartridge, opened my desk drawer, and replaced it with the spare I kept under the stamp pad. You know where everything is. I said. You label the drawers. That is not permission. You asked me to tab 12 years of statements. I inferred limited pen maintenance. She placed a paper bag beside the keyboard, soup, bread, and an apple. I ate. I said. You had tea at 7. That is intake. That is not dinner. I opened the soup because she had already removed the contract pages from beneath it. At 2:40, I made the mistake Daniel had predicted. The rights timeline contained an Anderson Press assignment from 2016. I copied the entity name into the 2022 transfer row without noticing that the later schedule named Anderson Holdings. That single error made it appear the rights chain was cleaner than it was. Renata saw the mismatch. Pierce. I kept typing. She placed her hand over the printed timeline. This row is wrong. I read it twice. The names finally separated. The room smelled of cooled tea and printer toner. The fire had fallen to embers. I'll correct it. You nearly gave Dorian the bridge he needs. I said I'll correct it. And then keep going until you make another mistake? My hand tightened around the pen. She removed the document from my reach. I am pausing the session. You cannot pause a deadline. My engagement gives me the right to stop work. The clause I had insisted on became the barrier I could not argue around. Renata pressed her thumbnail into her finger, then released it. I need an agent who treats evidence as carefully as he treats me, she said. Not someone who believes exhaustion proves commitment. The sentence left the library without raising its voice. She called Vivian and Daniel. Mara reviewed the entire rights timeline the next morning. I slept for 6 hours because Daniel took my office key and Renata kept the paper files. When we reconvened, the corrected schedule contained my error log as an appendix. No concealment. No performance of perfection. Mara signed the independent review. The methodology holds because the mistake was caught, disclosed, and corrected before filing, she said. Daniel looked at me. You shared responsibility. The building remained standing. I adjusted the edge of the appendix. He moved it half an inch out of line. Leave it. I did not. The flaw remained. Week 4 brought Dorian's settlement offer. He called Renata's private cell after Vivian instructed all contact to go through counsel. Renata put the call on speaker and recorded it with Vivian's consent under the applicable rules. Dorian's voice carried the polished patience of a man explaining gravity. He would release the current royalty freeze. He would return her backlist. In exchange, Renata would sign a non-disclosure agreement about the German advance, transfer all film rights, and pay Anderson 20% of her next 3 books. His method and goal sat inside one paragraph. Consolidate valuable rights before the imprint sale. Silence the accounting discrepancy. Use litigation costs to make surrender look practical. When he finished, Renata looked at Vivian's face on the screen. My answer is no. Dorian paused. You should consider what independence costs. I have. She ended the call. Her thumbnail did not touch her finger. The immediate relief came through a practical action. Vivian sent a written rejection and requested that the disputed royalties be placed in escrow rather than held by Dorian's operating company. Anderson refused, but the request created a clean record for court. Industry rumors appeared 2 days later. A trade newsletter reported that Renata's next book faced serious ownership questions. A distributor delayed its pre-publication commitment. Her audiobook partner asked for assurances. Social pressure entered every room before Dorian did. The porch light stayed on. Green tea waited by the window. Renata began bringing dinner without discussion. One night, she placed a container on the table and said, "This is not gratitude, it is loss prevention." What asset are you protecting? My agent's ability to distinguish corporate entities. I have independent review now. You also have noodles. A second recurring joke formed where straying could have taken over. Week 5 moved from contracts to corporate rights. Copyright registrations showed Anderson Press as publisher for the original books. Later royalty statements named Anderson Holdings. The pending injunction, however, named a third entity, Anderson Media Group. Clue 3. 3 entities. 1 claim. No complete assignment schedule. Vivian subpoenaed the corporate transaction documents through the commercial court. Dorian's lead counsel, Martin Vale, objected and produced a summary rather than the schedules. Judge Elena Brooks ordered the full schedules preserved for the upcoming injunction hearing. The absence of a public filing did not decide ownership. The transaction documents would. In the meantime, Renata's distributor suspended shipment of the independent novel. The film producer paused negotiations. Her backlist royalties remained frozen. Real threat replaced rumor. At the library, the brass paperweight held down the 3 entity charts. Its cold edge pressed into my palm each time I moved it. I told Renata where it came from. My wife used it on her desk. I said, after she died, I moved it here because leaving it in a drawer felt worse. The fire cracked behind us. Renata did not say she understood grief. She did not place a hand over mine or turn the moment into instruction. She moved the paperweight away from the contract and set it beside my fountain pen. The document stayed flat without it. That was all. Before the injunction arrived, the trade press published a photograph of Renata leaving my house after midnight. The caption implied she had traded personal access for representation. No one named a source. Dorian did not need to prove the insinuation. He only needed it to circulate before the hearing. Renata found the article at breakfast, her thumbnail pressed into her finger, then stopped. I can transfer the meetings to Vivian's office. I said, that would protect you. It would also reduce the gossip and teach them they can push me out of any room by lying about why I entered it. She slid the phone across the table. What does the engagement say? That you may choose the work location. I choose the library until the evidence moves to court. The decision stayed hers. Daniel arrived 20 minutes later with a communications plan and an agency disclosure form. He recommended a short statement confirming the professional engagement, independent counsel, fee arrangement, and conflict safeguards. Nothing personal. Renata approved every sentence. Nina Park, the publicist who would later handle her book launch, posted the statement and declined further comment. The rumor did not disappear, but it stopped growing. That afternoon, I reached for the brass paperweight and found a fresh felt pad beneath it. Renata had replaced the worn base so it would stop scratching the mahogany. You repaired it. I said, I repaired the table. The distinction is questionable. The paperweight is innocent until proven otherwise. She set a bowl of soup beside my contract matrix. I looked toward the spoon. It is not aligned. I said, it is soup. Pierce. Utensils have geometry. Eat before you create another appendix. I obeyed. The moment did not solve the press problem or the coming injunction. It gave us enough room to face both without turning care into spectacle. Week 6 began with Dorian's emergency injunction. He claimed Renata's new independent novel reused proprietary character archetypes and geographical elements owned by Anderson Media Group. The requested order would block publication, suspend the film talks, and keep royalties frozen. Vivian had 48 hours to respond. Pierce Wilson, literary agent, did not draft the motion. I built the publishing record she needed. At my library table, certified delivery receipts, rights schedules, copyright registrations, royalty reports, and the corrected corporate timeline filled 3 indexed binders. Renata organized exhibit tabs using the chronology she once used for novel outlines. Mara authenticated the digital records. Daniel assigned another agent to cover my active clients, so I would not damage 2 careers while trying to protect one. At midnight, the temperature dropped. Renata fell asleep on the sofa with my wool coat over her shoulders. I had asked before placing it there. She nodded without opening her eyes. I returned to the rights chain chart. At 3, the printer jammed. The paper tore beneath the roller. I stared at it longer than the problem required. Renata woke, crossed the room, and switched off the printer. "We have the exhibits," she said. "The affidavit references a clean copy. Mara has one. I should verify it. You promised Daniel you would stop at 3. The clock showed 3:07. I checked the exhibit index instead. Renata took the index from my hand. "Kept promise," she said. I went upstairs. The next morning, Vivian completed the injunction opposition. My rights chain timeline became an exhibit to her affidavit, not a substitute for legal argument. The professional line held. The hearing took place in week 7. The courthouse hallway smelled of floor wax and old paper. Dorian stood beside Martin Vale with 2 junior attorneys and the confidence of a man accustomed to opponents arriving tired. Renata carried no files. Vivian had the legal packet. Mara had the preservation declarations. I held the certified rights ledger. Dorian approached before the courtroom opened. "Renata, the offer remains available." Vivian stepped beside her. "Direct all settlement communications through counsel." I did not block Renata's body or speak for her. She chose her own answer. "No." Inside, Judge Elena Brooks heard the injunction request. Martin argued that Anderson Media Group owned the characters, settings, and derivative film rights through a chain of corporate assignments. Vivian asked him to identify the complete chain. He produced the transaction summary, not the schedules. Judge Brooks looked toward him. "I ordered the schedules. They contain commercially sensitive information. They also appear to determine whether your client owns the rights it seeks to restrain." Vivian called Mara first. Mara authenticated the email exports, delivery records, royalty files, and rights database. She explained the hashes, restricted folders, and the error appendix. Then I testified as the literary rights witness. My silver pen rested beside the certified ledger. I did not use it to pretend I was counsel. I explained the acceptance history, the payer name changes, the German advance, and the missing author notices. The rights chain timeline showed each document and the entity named on it. Martin asked whether the missing certified acceptance automatically voided the contract. "No," I said, "it creates an unresolved trigger issue that must be considered with performance and waiver." He asked whether the German advance proved fraud. "No, it proves the payment was routed and reported differently from the author's statement." Counsel and the court determined the legal consequence. Judge Brooks examined the chart. "This timeline is unusually disciplined," she said. "It distinguishes what the publishing record proves from what it merely suggests. Recognition in the proper arena." Vivian argued that Dorian had not established ownership of the future novel or film rights. She asked the court to deny the broad injunction, place disputed royalties into escrow, and order production of the transaction schedules. Judge Brooks ruled that afternoon. The publication injunction was denied. The film rights restraint was denied. Backlist royalties would move into court-supervised escrow, pending the ownership review. Anderson had 5 business days to produce the assignment schedules and foreign rights accounting. Temporary protection, not final victory, outside the courtroom. Renata's shoulders dropped when the distributor confirmed it would resume the independent release. I touched the sleeve of her coat rather than her back. She turned her hand and caught 2 of my fingers. The contact lasted until Vivian called us into the conference room. Then the next practical step began. Week 8 delivered the records Dorian had tried to avoid. The transaction schedules showed Anderson Press had transferred certain catalog assets to Anderson Holdings. The schedules excluded Renata's future works and unexercised film rights. Anderson Media Group later acquired the imprint name and distribution operations, but not the omitted rights. The chain was broken exactly where the clues suggested. The foreign rights ledger showed the German advance had been received, moved through Holdings, and classified as a marketing recovery rather than credited to Renata. Vivian filed a sanctions request and a motion for accounting. Dorian requested settlement. The negotiation lasted 4 days. Martinvale and Vivian reviewed every clause. Daniel represented the agency's limited interests. Renata retained final approval. The signed settlement released the non-compete in writing, returned the backlist rights, confirmed Renata's ownership of future books and film rights, paid the withheld royalties and German advance with interest, covered legal and audit fees, and barred retaliation. Dorian's company accepted a court-approved accounting monitor for 2 years. Judge Brooks reserved sanctions against the entity for the incomplete initial production. Renata did not owe Dorian 20% of anything. The settlement closed on Friday at 3:40 p.m. At 4, Renata signed a new representation agreement with Celia Grant, an independent literary agent who had no personal connection to me. Vivian remained her copyright counsel. The rights management database transferred under a documented handoff. At 5, Daniel closed my paid engagement. Every invoice was satisfied. Every file was transferred. Renata's income, access, and representation no longer depended on me. Daniel stood in my office doorway after the final signature. "You let counsel practice law," he said. "I am adaptable. You accepted an auditor under protest. You slept before the hearing. I lost 7 minutes to printer failure." He smiled. "You shared the load. Pierce." Then he left before I could straighten the transfer receipt he had placed crooked on my desk. That evening, the professional team gathered in my library for 1 glass of Malbec. Vivian raised hers to clean records. Mara toasted restricted folder discipline. Daniel toasted sleep, then watched me until I drank. Renata sat in her designated chair beside the window. No contract lay between us. The brass paperweight remained beside the fountain pen. After the others left, Renata and I stayed by the fire for another hour. We spoke about her next novel, my agency, her fear of beginning again, and the fact that neither of us knew what to do when a crisis stopped providing structure. I did not ask for anything. She left at 10. The porch light remained on until her car disappeared at the end of the street. The next morning, her text arrived at 9:12. Last night meant so much to me. I read it twice. The words referred to a night with no leverage, no deadlines, and no professional duty. That difference mattered. I called her, "Pierce?" "My professional engagement ended yesterday," I said. "Your rights and income no longer depend on me. What I ask next changes none of that." A pause. "All right. Come over tonight." "For work?" "No." The brass paperweight sat on the corner of my desk. I moved it away from the blank page beneath it. "Dinner, wine, no contracts, no client meeting, and no expectation beyond the evening." Her breath caught once. "And what are you asking?" I looked toward the 2 empty wine glasses on the library shelf. "Should we do it again?" "Dinner." "Dinner. Conversation. The fire. You may leave whenever you choose." "Yes," she said. "I'd like that." At 7, the doorbell rang. Rain silvered the porch steps. Renata stood beneath the light in a simple sweater and dark trousers, carrying a paper bag. "What is that?" I asked. "Dinner." I invited you. You make tea and call it hospitality. That is inaccurate. You own 3 pans and use none of them. She stepped inside after I moved back from the doorway. The library fire was already lit. 2 glasses of Malbec waited on the mahogany table. The brass paperweight sat between them, but no document required its weight. Renata placed the food beside it. Still cold, she said, touching the metal. It usually is. She picked it up and moved it to the bookshelf. The table remained clear. I reached for 1 wine glass and aligned it with the other. Renata nudged hers out of line. Leave it. I looked at the uneven glasses. Then, at her, I left them that way. 9 months later, the launch for Renata's independent novel filled a restored theater downtown. The German edition had returned to print. Her withheld royalties in advance had been paid. The film rights were under option through a deal Vivian reviewed and Celia negotiated. The non-compete release lived in the agency archive with the settlement order. Dorian no longer controlled her catalog. Anderson's accounting monitor had identified 2 additional author underpayments, and the court sanctions process remained active. My agency stayed profitable. Celia handled Renata's publishing career. I handled mine. Nina Park, Renata's publicist, managed the line of readers and the television crew near the stage. I stood beside the curtain with the clipboard, not because anyone needed me to manage the schedule, but because holding paper remained easier than standing empty-handed. Renata finished signing a book and took the microphone. Before the next reading, she said, I need to clarify something for the publishing press. Celia stood near the front row. Renata pointed toward her. Celia Grant is my literary agent. Vivian Shaw is my copyright attorney. They control my rights and contracts because they are excellent at their jobs. Then she looked toward me. Pierce Wilson is my personal partner. He has no authority over my income, deadlines, or career. The audience laughed. Renata smiled. He does, however, still align wine glasses when he is nervous. Every face turned toward the curtain. I checked the clipboard, even though the schedule had not changed. Nina leaned toward me. That is your cue. I stepped onto the stage. Renata reached for my hand in front of the readers, journalists, Celia, Vivian, Daniel, and Mara. Her choice was public and separate from every contract we had closed. After the launch, we returned to the library. The wool coat hung beside her sweater in the entryway. Green tea waited near the designated chair. 2 glasses of Malbec sat on the table, one slightly ahead of the other. The brass paperweight held down the launch program. I reached to straighten the glasses. Renata lifted the paperweight and placed it in my palm. The familiar cold weight remained. Then she took my other hand and led me toward the fire. I left the brass on the table and went with her. The end. Closing thoughts. Core lesson. Trust grows when competence, honesty, and consistent care protect another person's choices without taking control of them. Green flag. Healthy love respects grief, professional boundaries, and independent agency. It never turns representation, rescue, money, or career pressure into emotional obligation. Please like and subscribe so we can share more stories like this.